All right, so this video is going to be an excerpt of the conversation I had with District Attorney Matthew Lusink today, and I think that it does a good job of showing that the District Attorney is more interested in securing a higher conviction rate and boosting his stats as a prosecutor than he is actually in upholding the law or prosecuting people for violating the law, in reference to Sean Tim Jr. and the evidence I provided that he, in fact, committed bail jumping when he gave the wrong address or a false address in relation to his bond. District Attorney's Office. Hello. Hello.
We're right with you.
Yep. So I have a couple questions.
Okay.
Sean Tim Jr., why is he not arrested yet?
Because I don't know that there is any way we can prove it beyond a reasonable doubt that he committed the offense of bail jumping.
I provided verifiable proof from his father to the Sheriff's Department and Red Granite Police Department that he falsified his address on his bond paperwork.
And I have read that report. I have also actually read the jury instructions for bail jumping, which I can let you have this copy when we're done. We have to show that he intentionally failed to comply with the terms of his bond, meaning that he had the mental purpose to fail to comply with them, that he knew of the terms of the bond and knew that his actions did not comply with the bond. And I believe the evidence would show is that he was still getting mail at the address in Red Granite. He was still basically there on a daily basis. He may not have been sleeping in that, but...
And that's the residence that his victim is located at. Why is he allowed to go there? That's another question I have. He was released on bond to the address where his victim maintains as their primary residence. That's the county putting him in connection with the person he hurt and allowing him to do it again.
That's not what you made the complaint on.
It doesn't matter.
Well, it does because they have to actually investigate that. Here's the thing. The purpose of the provision regarding your address, it's meant to ensure that you're getting notices and that you're appearing in court. He's doing that.
That's irrelevant. Whether he's appearing in court and getting notices. Listen, I still get mail to the jail, and I haven't been there in quite a while. Okay? Some people don't update their addresses in their systems and things of that nature, so the mail thing is it's ridiculous. I provided verifiable proof that he lied, his family lied, to affect his bond to get him out on bond. He is not living at the address he says he's living at. Whether he gets mail there or not is irrelevant. He does not live there.
He received a significant cash bond, so I don't know.
$4,000 is not significant.
In Waushara County, it is.
No, it's not. You yourself tried to give me a $10,000 cash bond for absolutely nothing. Charges that were never even pushed through. You guys had to manufacture some crap about threatening a law enforcement officer with no proof.
We're not going to argue about that.
My point is, you guys issue higher bonds for lesser offenses. This dude is preying on children, and you give him a low cash bail where business owners can easily pay it. I've provided proof that he falsified records, and actually in violation of statute 943.39, I believe it is, in fraudulent writings, which is a felony, class H, punishable by 6 years in prison or a $10,000 fine.
You're talking about crimes against property. 943 is crimes against property.
If you read the subsections in it, it covers bond. That's where I got the information from. It covers bond. He falsified bond information in order to affect the result of his hearing. He lied to the court, to an official, to yourself, to the judge, to the bailiff, to everybody in that room. He needs to be arrested. His bond should be revoked immediately. And for the fact that
they're not going to revoke his bond. He doesn't meet the statutory criteria for it. And furthermore, I actually read the statute regarding conditions of bond, and specifically looking at that, as I read it, conditions related to your residence, they are meant to ensure that you appear in court. And I also tell you, I've been a prosecutor a long time, the only bail jumping charge for failure to update address, the only one that made it past preliminary hearing was one where the person had sold her house and moved to Kentucky and had not updated her address with the court. So
that's different. That shows a clear intent to flee and not follow through with the court proceeding.
Right, and that's why I thought that was violent.
This here shows a clear intent to hide the fact that he's living at a separate address and still be in contact with the victim of his crime. Okay? So if there's a form I can file or something where you can then look into that, because the man claims he lives in one place, his family claims he lives in an entirely different place, but the place he's saying he's living in, according to his bond paperwork, is where the victim of his crime lives, which would put the county in some serious trouble. So it needs to be looked into immediately. It's asinine that you guys are sitting here grandstanding on the law that you know a little bit better than I do. Obviously, you went to school for it. When you could just say, "Hey, man, he messed up. We'll bring him back in. He can have a new bond hearing, and he can correct the information."
I want to get him on the stuff I can prove beyond a reasonable doubt. That's what I can.
You can prove beyond a reasonable doubt that his bond paperwork says he lives on Horn Street, which is the address his victim lives at.
And if he's still going there and getting mail there,
he shouldn't be allowed there, period. The victim lives there. He shouldn't be within like 1,000 feet of the place.
I will ask Brett Granite to look at if the victim actually lives there and if there has been contact.
I can provide you proof from.
I will reach out to them myself.
I will provide it for them. I can provide it to you. I can provide it to them. Proof from not only Kelly Tim, which I'm now allowed to speak about because that got thrown out. I can provide you proof from Sean Tim Sr. as well that he goes there but does not live there according to what they say, and that the children live there.
The children, as I recall, were not the victims of the crime.
That's not what they said. They said the crimes were alleged against their grandchildren. His own children.
Crimes are possession of child pornography and capture an image of nudity without consent.
I understand that, and that's what part of my problem is here. Okay, they're saying the crimes were committed supposedly against his own children, taking pictures of his own kids and things of that nature, and now he's going to that address repeatedly, and there's nothing being done about it. I provided proof that he falsified documents, which is fraud. He falsified a legal document, but you're telling me he can't be arrested for it.
I do not think, given these circumstances there, that I can show that he was, because he's getting his mail there and he's visiting there, I don't believe we can show a bond violation, which is what was referred to me for an opinion.
Attorney Lusing, listen, man, I have quite a few people watching this and paying attention to what's going on around this scenario, okay? If this was presented to people to make a determination on it, I'm confident they would say, for a fact, this dude lied. He does not deserve to be out in public. Why are you allowing him to be in public?
Well, I've done over 100 jury trials, including over 30 in this county. I don't agree with that, having actually had to make cases to juries in Waushara County. I don't believe I could prove the charge of bail jumping beyond a reasonable doubt.
The difference is you guys are viewed as the bad guys because of how your court system operates. I'm trying to not only hold this dude accountable, bring a more positive light to this county system. Okay? I'm offering you the ability to do that. If you put this man on trial for felony bail jumping, which is what he did, I can guarantee you would not lose. If you have a jury of his peers from this community, you would not lose. I can promise you wouldn't lose.
Okay, well, I will trust my judgment on that. I think we're done today. I would know, though, if you say you're coming at a particular time,
I got delayed.
I'm prepared for that.
I'm sorry about that, sir. That is my apologies. I got delayed due to not having enough gas in my vehicle and things of that nature. I had problems with money and things of that. I in no way intended to disrespect you not showing up on time. That was my fault. I appreciate your time.
All right.
I just would like to reiterate one more time that if you were to put this man on trial for bail jumping, I could all but guarantee you citizens of this community would hold him accountable for it.
Well, at this point, I'm focusing on prosecuting him for the crime I have him charged with, which, frankly, is much more serious than a Class H felony. We're talking about multiple Class D felonies.
I completely get it. Yeah. And that's a problem. There's a rash of this stuff in our community with people preying on children, and I'm trying to get to the bottom, get rid of it. I don't want them here.
And
I'm trying to help you.
Our county's aggressively prosecuted that.
I wouldn't say so. This Shiloh View who tried to bring kids into the woods, you guys gave them 3 years in prison. 5 years, 3 in, 2 out, plus
and
good time.
Do you know much about the actual circumstances?
Yeah, I read all the paperwork on CCAP.
Okay, well, that's not everything.
Then it all needs to be released for public record. That's unnecessary. You guys are withholding records. Why are you withholding records from
I'm not withholding anything.
Okay, then why is it not everything released on CCAP?
Because things like police reports, interviews with people, those are not things that are put on CCAP.